Good morning, everyone. Welcome to the AI patent. Good morning, everyone. Welcome to the AI Patent Power Hour. Just to set the agenda, we would start the session with a fireside chat, which would be followed by the launch of our report, AI Patents Driving Emergence of India as an AI Innovation Hub. Post that, we have an AI patent workshop led by the sagacious team, where you'll get all your answers related to AI patent filing. With this, let me welcome our panelists for the session. Anand Subhash from Concept Bytes. Anand is a postgraduate in engineering and has about 2 decades of industry experience with Philips. He holds multiple patents and believes that products are built over time with patience in addressing the unmet and unarticulated needs of the customers. He's currently bootstrapping his enterprise startup and is enjoying sustained multi-year traction and steady growth. Welcome, Anand.
Thank you, Neha. Happy to share my inputs.
Our next panelist is Neerav Parekh from VPhrase. Neerav is the founder and CEO of VPhrase, a digital marketer turned AI entrepreneur. He wants to use his AI venture to help companies communicate the insights in their data to their people at scale. Welcome, Neerav.
Thanks, Neha.
Next with us is Gagandeep Rihar from -Zero. Gagandeep is a deep tech engineer, AI researcher, and author presently involved in multiple projects related to applied artificial intelligence, product design, and interdisciplinary research across the domains of cognitive and human-centered AI and autonomous vehicles and robotics. Welcome, Gagandeep.
Thanks a lot. It's a pleasure to be here.
Lastly, we have Vaibhav Henry, our moderator for the session. Vaibhav is a master's degree with a major in machine learning from Delhi University. He's at a position of AVP and heads high-tech practice at Sagacious IP. He has around 12 years experience in patent research with a focus on patent monetization. He's a consultant to 12 Fortune 500 companies. Welcome, Vaibhav.
Hi, Neha. Thanks for having me.
Now, with that, I leave the stage to our esteemed panelist and Vaibhav to take it over from here. Thank you.
Thanks, Neha. So in this session, we would be talking about everyone's experience. VPhrase's, Neerav's experience, Gagandeep's experience, Anand's experience in patent filing. What were the challenges that they faced, and what do they think about, filing patents here in India? So it would be a candid chat, and that's why we call it a fireside chat. And we will get to know what else we could do. We'll try to narrow down on the things that we feel we as citizens could do, or we as entrepreneurs could do to make things better, and even us as companies can do to support the entrepreneurs better and the SMEs better here in India. All right, so let me dive right into it. Let's start with a very generic question. So I'll start with Anand. So Anand, how important do you think patent filing is from your perspective for a growing AI company?
Yeah, thanks, Vaibhav. So if you look at it, the first step is we engineer a solution around a product or a problem, right? So once you engineer it, you actually have it in the field with your customers, right? So then what happens is any learned or experienced observer can over time understand what you have done it, right? And either he can copy it or patent it, right? Both of these things are dangerous for us. Like, for example, if he copies it, you lose your unique advantage. But if he files a patent, he will end up giving your revenues to him, right? So to tackle that, one way is we go forward, right, and patent it, right, and have exclusive ownership of the technology you have in the field, right? So be it AI or any technology, that's how I think patent helps us.
Exactly. Great, Anand. So I think there's an important question there as well. That how do you shield yourself from such discussions? because there are multiple places from where the product development could come. It could be from your clients, and if the clients are questioning you, uh, that's or questioning or they want a new feature, that's a very important area that we have also realized, when while supporting companies, uh, that a lot of questions come from the users itself. So but at the same time, you are the guys who are the solution providers, so as you pointed out, it's important. Neerav, any thoughts on that front?
So I think patents are certainly important. Otherwise, we won't be doing them. So
Right.
I'll tell you our reasons for filing patents. One
Okay.
is obviously, like Anand mentioned, that you need to protect your invention.
Right.
So I have my own doubts in terms of how much of protection does it enable, and I
Right.
think we can discuss that as a separate topic
Right.
during this conversation.
Right.
But I think protecting the IP is certainly one of the benefits. But I think there are some other collateral benefits as well. Uh, Patents help if you're a young company, if you're a small company, not with a very strong brand name. I
Right.
think what patents do is it adds credibility to what you have
Right.
to offer. So a lot of people around in the market saying that we do this, we use cutting edge AI and everything.
Right.
How do the clients or vendors or whoever separate who are serious players and who are not?
Right.
So I think the patents by themselves are one of the factors that add credibility.
Right.
I think there are other benefits as well. Uh, if you're looking at raising funds, again from the same point of view, investors,
Yes.
because there are a lot of startups coming and asking for funds from them. How do they understand if what you're building is really good, right? So
Right.
unless you are a tech investor and you understand tech really well, a lot of investors don't understand technology. So for them, this becomes a way of filtering out companies. They think, okay, if you file patent, that means you're building something which is innovative. So from the
Right.
investor's perspective, also there's a benefit. But I think one additional benefit that I'd like to talk about, which not many people talk about, if you really want to hire really sharp talent, I think
Right.
patents certainly help. So when people who are looking for jobs, they look at companies. These days, everyone researches companies before they apply. They know everything inside out about you, about culture, about the kind of work that is being done.
Right.
So if you're a company which is regularly filing patents, then that gives a very strong signal to them that the work that they would be doing when they join the company would be very innovative. So that
Very good point.
we've seen that has been a fantastic benefit that we've got because of all the patents that we are filing. So I think these are the benefits. Protecting of the IP is one of the benefits, but I would say the other benefits are equally strong.
Right. Right. And I feel that, that is a position when you go from an individual inventor to being to uh, corporatizing the IP. You are trying to build functions around it. So I think so in the journey of patent filing and understanding what patents, the value of patents, I think it's a journey, and some companies are move ahead, and they try to imbibe that culture in the company, and that's when you start seeing all of these factors, as you have been seeing. So I think it's a logical journey, and yeah, it's good that companies are realizing that.
Yeah, absolutely.
Gagandeep, your thoughts, please.
Yeah, that's exactly like mostly people think that these patents are just IP protection, but like if showing a reality, patents do comparatively just do 30% IP protection. Let's say if somebody wants to do a copy or IP or something, they can do. They can make certain changes in the design and all. Particularly this is
Right.
applicable for software patents. They can make little changes in design, and if you, let's say some big MNC wants to target you while you are a startup, so that is not. But patent filing is a strategic game. It's a very cost intensive game. So the
Right.
biggest thing is that you have to strategize it. Like, right,
Right.
since we have, let's say we have three target markets. Okay, we have target market of US, let's say Singapore and India, right? So
Right.
it's not always important that okay, we have to file all these things in one go. Basically,
Right.
that is very important, how you
Absolutely.
strategize that. Let's say we have our first priority is raising funds, so
Right.
accordingly you strategize. Okay, we have this one. Okay, we have filed in India, and then there will be time for granting and all. Then we file PCT application. We manage our resources time by side, because
Absolutely.
this is not something that you can keep on putting money in.
Right.
And also it gives basically what you call a quantifiable value to your IP. Normally, when you are discussing valuation with investors,
Right.
normally particularly for early stage startups which have little traction, you need to
Right.
give a quantifiable figure. So let's say if you quantify a certain patent to be worth like this much, considering the importance, it will add to the valuation and it gives you a better negotiating power. So that is what this is, a total strategic game. It is not something that okay, you file a patent and it's done. No, you have to actually plan your entire journey. What do you actually want from your business? What are your priorities? And you have to plan your journey over a course of, let's, because patent is not something that is done in basically 1 month or so. It might take you 2-3 years. There are a lot of hearings. So that is a very important thing that I believe, like more than IP protection, I find the other benefits of patents like more what you call more powerful.
Absolutely. Agreed. So I think there are very important points here. So for example, Gagandeep talked about strategy, and there could be a global. You would have some business perspective. You would have a business strategy. So another important aspect, Nirav talked about, incentivizing people, incentivizing, that could be monetary, that could be just from the perspective of culture, on how the culture, just being able to show their employees that there is a culture of innovation. So these are important points. So for example, you have a strategy. Gagandeep mentioned that you have a strategy, and the strategy, the business strategy, the bottom line that comes out from this is that the business strategy should be in line with the patent strategy, and because your resources are limited, and you have to have a strategy in place. Which are the geographies that you are going to enter? And because it's patent is a protection, so you think about that, before entering you should have something such that people don't start copying your inventions, because big companies, they have a very set patent process, and your patent is also published in 2 years of time. So as soon as it's published, it's for public use, or it's available to public. It's not for public use, but it's available to public, and anyone could take a look at the technology, and if it's great, they could copy it. So very good points there. It depends on strategy. It's expensive. Patents are expensive. So that there has to be a strategy in place, and it has to be in line with the business strategy. Nirav pointed out, the underlying, how a company should perceive patents. Very important points there as well. That your employees should perceive. They should be sensitized. They should know what patents are. We will get into that question. I think that is the next logical question in this flow. How do you sensitize the employees? Of course, there are incentivization programs. You make people aware about that, but we get, I think we'll come to that as well. And let me check. Yeah. So I think we could talk a bit about sensitization, or how do you let people, or as your employees, or or even people among yourselves, how do you make them aware or sensitize them with the information about patents? And maybe how do you make sure, or what are the what is the research that you have to do? If I had to simply put it, what is the research that one should do to understand? Of course, we saw that strategy is a big part, but all of that comes later. How do you start? If I have an idea, how do you start about thinking about what to do next? So you all must have encountered this when you filed the very first patent. So I
Right.
think we can talk about that. Maybe we can start with Gagandeep.
Yeah, so basically the thing is, normally people think that okay, if you have some making something new, that okay, we'll go for patent, but that is not the exactly process that you should follow. There are
Right.
multiple IP protections, right? People think okay,
Right.
the patents are the only one. There, let's say there are copyrights, then there are patents, and obviously you can also go through the part of research paper. So you need to
Right.
actually understand first that okay, what is your basically invention is, how much market value does it have, and that is very
Right.
vital. If something would work, like there is best way for everything. If something works better as a research paper, let's say, right,
Right.
you have done a little modification to a very existing framework, right,
Mm.
where there is very lot of ingenuity factor, and let's say it might not be able to benefit you monetarily, because there is always a value that okay, this is something very proprietary, it is what will define our success, and there is something others also. So you need to first understand your own invention, that how much importance will it hold in basically creating a business. And that is how you should choose. It's not always right that go for patent for everything, right? So
Right.
that is a very important thing, that what is the right kind of protection. And obviously that there are proper parameters, and that is why normally often people, to optimize costs, they say that okay, we will file the patent on our own selves. That is a very, what you call, big blunder that they often make. It is always best to hire an attorney, because they know better, and often in our case
Right.
they have also, attorneys know what is the best and how much basically there are claims in a patent. So it is very vital
Right.
that okay, how much broad a patent is, will it actually add monetary value or all. And that
Right.
is very vital, because
Right.
patents is not just a technical game. You might easily make an invention.
Right.
It is more of a legal game, techno legal. That is what we word use.
Yes.
And
That is correct.
hiring a patent attorney is very vital, because they will help you let making you choose what is the right option. Obviously they make changes too, because there is, also there is no guarantee that a patent will get accepted. So that thing also have to, you put money on novelty search and all, right, and then patent doesn't get
Right.
accepted. That is something that is
Right.
very disheartening for a startup. So that's
Right.
why this, I always point out, always hire a patent attorney. You do not have to go for very high notch ones, but yeah,
Right.
do not try to do this thing yourself, because it's a legal game. Even if you have a
Right.
simple idea, you can get it patented if you have to draft the patent application rightly. But
Right.
if you have, there are chances sometimes you have a very innovative idea, but a poor patent application will lead to the rejection. So these 2
Absolutely.
points are very vital.
Very important points, Gagandeep. And Anand, very practical points. Anand, any thoughts on that?
Yeah, so I think in addition to Gagandeep, right, the first thing is idea and invention, right?
Right.
So
Right.
first thing we have to separate it out, right? So only when you can measure the value out of it, right? Is it like process improvement or a improvement of an economic or some activity, right? So whether this is establishing it, right, very clearly, that qualifies to think on whether to patent it or not, right? Then of course you have to look at your strategy, right? How much of it patent or anything to be patented, right? So that's the first step, right? Whether
Right.
is it just an idea or it has become an invention which is stands by itself in front of the patent office, right? Now the next step is to understand like who else is into it, right? You are not alone in the world. Someone
Right.
else would have also patented or
Right.
researched into it, right? So you
Right.
do the literature survey, I mean, or even the patent search, or
Right.
from my side, what we do is on top of it, we'll also look at our competitors. We know like who are into this game, right? How far they have gone, right? With their patents or published areas, right? And see like how much extra you have and whether still it will it stand, right? Yes,
Right.
it's a costly process. So strategy, the value it brings to table, and the differentiation it still has in the market. All these are factored in, right, before we start with the patenting process.
Absolutely. Good points there, Anand. I'll summarize that as well. I'll try to build something. Neerav, your thoughts?
Sure. So before I answer that, Vaibhav, if you can just clarify, you said you wanted to understand how do you sensitize the employees, right? The team.
Yes. Yes. Yes.
What exactly did you mean in terms of sensitization? So did you mean you need to, how do you encourage them to?
Yes. Yes. Yes.
Uh,
So there could be incentivization programs, one thing that we talked about. And then, in terms of sensitization, making sure that they actually submit the ideas, making them aware about patterns and having them submit ideas are two different things.
right.
So, right.
So I think it's a combination of things that need to be done. That is some things that we've done and we've seen that works. I think the
Right.
biggest incentive that people see and that really motivates them is that their name gets featured in the patent as one
Right.
of the inventors. So I think there can be no bigger motivation for anyone, and these young fellows in technology domain, to know that their name would feature in the patent and they'll be one of the inventors. So I think that is one.
Right.
Uh, Another thing that we've seen is to define a clear owner within the team who runs the patent as an initiative, patent writing as an initiative. So you cannot just leave it open, because everyone has their own day jobs, everyone has their own responsibilities, and patent is never the main responsibility of anyone. So you need
Right.
to
Exactly.
make sure that you have one person at least in the team where patent is mentioned in his KRA, and he's
Okay.
responsible for leading the initiative, ensuring that we are continuously looking out for, because I'll give you an example of our company, right? So we're building something which is very, very path breaking in energy space, natural language generation space, and very
Right.
few companies around the world do that. So everything that we do practically is patentable. So,
Right.
but the problem is, because everyone is running behind the deadlines, we have product roadmap, we have to build
Exactly.
things, and all of us are always running behind deadlines, right? We are always late.
Right.
So in that, things get forgotten and things get
Right.
deprioritized. So if there is someone who's continuously looking out for, okay, yeah, this is something that we build, probably has and goes through all the parameters in terms of what value would it provide, does it make sense to protect this or not, going through all those parameters, continuously keeps an eye out. And the moment he sees something interesting, he immediately points that out, gets the team involved to create an initial draft, and then from there he takes it up and then make sure that with the attorney he would do the full filing work and everything that is required back and forth with that. I think that has certainly helped, having a clear owner. And besides, whenever we're filing a patent, we getting a FER, or we getting a patent granted, we do make a major announcement within the company. We do call it out, and just the whole hype that gets created
Yes. Yes.
gets the attention that the patenting process deserves. So I think combination of all these things has helped us ensure that whenever we have anything interesting, whenever we have things which can be patented, we generally are there for that.
Yeah.
That very good points, Nirav. Gagandeep, you wanted to add something?
Yeah, this was actually very important thing.
Right.
Normally, I've seen in the companies that they have this right that everything, the owner, inventor, everything is the company. But
Yes.
one thing that people don't understand, there are two people,
To
two parts in the patent. One is the
assign
person which has
assign
rights, the body which has rights over the patent, the basically the business rights and all. Then there are inventors. So there is
inventors. Right.
no harm if, let's say, a team of 5 people have made a certain patent, like certain invention. There is no harm if you put their name as an inventors, because the patent will be granted in the name of the company or the
Right.
owner, and that person will have all the rights. But
Right.
if you have the employee's name in the list of inventors, that is very vital, because they will it will also add value to their resume, their CV. So putting their name as an inventor, they will not be able to exercise any rights, they will not be able to claim it. But it's like a it's like a very good goodwill gesture.
Right.
And that is often, mostly companies have this contract that okay, everything will be done in the name of the company, the inventor is the company. So there
Right.
is no harm if you put the name of the employees as the inventor, because the rights will be always be exercised by the company only, the patent will be the name of in the name of the company. And that is very good way to incentives, basically give incentives to the employees.
Right.
And this
Right.
is a culture that is shifting right now, basically, as more and more companies are becoming aware
Right.
of what exactly are the parts of a patent. They
Right.
get to know that okay, there is no harm in putting the inventor's name also. So yeah, this
Right.
is a
Right.
trend that we are like shifting to in India right now.
Absolutely. Very important points. If I had to summarize this whole discussion, Anand, do you want to speak something, or should I summarize the discussion on this point?
Yeah, please go ahead.
Okay. Okay. So again, as we see, every company in its life cycle, where it is, depending upon that, we saw that, Gagan pointed that you should always take help. That is the first step. When you think about filing patent, it's a techno legal document. Very important catchphrase. It's a techno legal document. You might think technically, and therein lies, when you file your first patent, there also lies the problem. You would try to explain. Sometimes you have to work with lawyers, and you would think that what I have conceived. Sometimes people come to us and they say, I have thought of a novel idea. So novelty is something that has to be evaluated, and then they face problems with the legal side, suggesting that they are not understanding my invention technically. So it's a very important part that it's a techno legal document, patent which has claims. Claims cannot be written by people who have no idea about patents. So it's important to have from, as Gagandeep pointed out, it's important to have a patent lawyer, a patent agent, someone with knowledge about patents. And there are a lot of patent agents. We'll talk about this in our presentation as well. So in the third session, Asta would there are government incentives as well, and there are patent agents that have been assigned who do your work, who do your filing for free. So there are different parts. Drafting the patent is one. We saw there is filing of patents, and there are people who do it for free as well. There's a whole list of there are, I think, 289 patent agents, and each day patent agents are getting added. In 2020, there was a new list. There were new annexures of who are the people whom you can contact with their phone numbers. We'll take a look at that as well. So that is very helpful for people who are just starting out, who are thinking of filing their first patent. So that is very important. But companies that have moved on, they have sensitized their employees. As Neerav pointed out, having your name on the patent is very important. But at the same time, they have so much responsibilities on the plate, and we have seen this very often, that so much responsibilities that they are thinking about the product, not the patent, because they are dealing with product releases. Anand would have faced that. You're always dealing with the next iterative increment in the product, and making sure that your customers, if you're customer facing, or if you're business facing, businesses always grow, so you have to have all of those competing features. You have your uh, competitors, so you need to make sure you're pushing out the updates. Among all of this, it the feeling of patent is lost, and that is what Neerav suggested very well, that you should have a point of contact with KRAs defined only for this process. And so that is how companies grow, and they realize that it's not only about the thought of patent, it's also about the implementation as well. So as and when companies grow, they start realizing that and and that's how they have this complete process. They have this sensitization, they have the implementation in their companies. Points, I think this is very practical knowledge that we have gathered here. And I think we are running out of Neerav.
So when I said that you should have one dedicated person, I did not mean
Right.
full time, because in a small team, in small companies, it's difficult to have one person full time. But
Right.
identify someone and just add one more item to his KRA, that yes,
Yes.
what you need to do.
Exactly. You should have a go-to person with that KRA. Right. Great. So I think we are out of time, but it was a very healthy discussion. I hope you guys enjoyed it. We also had to talk about government sanctions, government incentives, and all of that. But we have a whole webinar, or the later part of the webinar planned for that. So we'll take up all of that in that section. Right now, I would like to pass it on back to Neha. I think we have, because all of the aspects that we talked about were more from the perspective of patents and SMEs and companies where they are. We still have to talk about AI. What specific aspects we need to implement in AI from the patent perspective. That would be the third section. The second section is the Neha would. There is a presentation that we have done, or there's a report, in fact, that NASCOM and Sagacious and India AI have done, which is about filing of AI patents here in India. So Neha would be revealing that, talking about that report. So it's in front of you. I'll pass it on to Neha. Thanks everyone. Thanks Anand, Neerav, and Gagandeep.
Thanks, Vaibhav.
Thank you.
Thank you. All right, back to Neha.
Thanks, Vaibhav, and thanks all the panelists for such an insightful discussion and all the practical considerations that we should consider while the companies think of filing a patent. Now, with this, and I launched the report that we have made focused on AI patents, driving emergence of India as an AI innovation hub. And I thanks everyone, all the panelists, to be there for being part of this report launch. Now, next slide, Asta. Before we talk about the key trends in India's AI patent filing, I would like to quickly touch upon the patent filing trends that are going across the globe. So what we have seen during the last year, despite the GDP going down, the pandemic, ramping companies' businesses, international patent filing grew 4%. And if you look at what happened in India, what we have seen over the last 5 years is that more than 70% of the technology patents that have been filed are being done in the emerging technologies domain. And out of these emerging technology patents that have been filed, AI accounts for 6% of these patents. So what we see is that overall, there is a focus on innovation, there's focus on IP creation, and there's a focus on emerging technologies. Now, if you look at how AI innovation has increased in India, what we have seen, it has gained a lot of traction over the last decade. And India has been ranked 8th in terms of AI patent filing and 4th in terms of AI research papers globally, which sees, now globally, India is being positioned as an emerging destination for AI innovation. Now, moving forward with AI patent filing trends, over the last decade, India has seen over 5,000 AI patents being filed, and 94% of them have only been filed over the last 5 years. So there has been no patent since 2002, but if you look at more than 5,000 patents coming in the last 5 years, it just showcases the strength that we are building in AI. Of all the patents that are filed, 60% of the patents filed were originated in India, which means they were first filed in India and they had their origination in India, not in any other developed country, say a US or a European country, but majority patents are originating in India. Consumer electronics, personal computing devices, healthcare, transportation, and telecommunications were the leading vertical focus areas. Machine learning and computer vision were the key focus area in terms of technologies. Now, if you look at assignees, I mean, specifically business assignees, if you look at, then technology sector leads with a share of 47%. Overall, 40% of the patents that were filed were granted over the last decade. And of those 40% granted patents, 63% of the patents came from the MNCs. Now, these were the key trends that we looked at, the AI patent filing trends in India. What we also interviewed a lot of industry folks who have been filing patents in the AI domain and wanted to hear them out on how they see this trend going forward. So what we heard from them is this uptrend, which has picked up in the last 5 years, is expected to maintain over the coming years. And the key reasons for the same is that there is people have realized that patent filing and IP creation is important because you can monetize the patent. It's an important asset and it creates, a significant competitive advantage for the company also. Also, people have realized that protecting their intellectual property is becoming more and more important so that nobody else can copy it. And if they do, then they can safeguard their own interests. Now, in terms of the areas where we will see more of patent filing is expected to be very diverse because now the focus is more on AI applications, which might work across different verticals and segments. And thus we will see more and more diverse AI patent filing going forward. Now, also in order to reach that full potential of AI patent filing in India, it's important to look at certain recommendations that we came across while we spoke to people. It's important for us to understand that for small companies to really go towards IP creation, they need a lot of support. And for that, we need to set up a coalition of stakeholders who can mentor and support these small companies and startups. Also, though there is increasing awareness, still there is a lot of room that we can cover where we need more initiatives which are focused on building awareness on importance of patent filing. The third thing that we came across while we spoke to people is the time that on an average it takes for a patent from being filed to being granted or rejected is nearly around 4 years, which is a lot of time if you compare the similar timeframes globally. So there's an important need to curb inefficiency in the patent examination process. And for that, there has to be significant steps that we need to take today. So those were the key recommendations that came across while we spoke to the key industry folks. With that, I close the key report findings. You can reach out to NASSCOM community and NASSCOM website for the complete report. and hope you like that, and we'll be happy to hear your feedback. Please do share the same. Now, I'll share the links of the report soon in the chat. With that, I leave the ground to Vaibhav and Astha to start the workshop on the AI patent filing process.
Thanks, Neha.
Thank you, Neha.
Yeah. So I'll hand it over to Astha. Astha is actually Astha heads the patent drafting, team here in Sagacious, and she is the she has experience on how to draft patents. How to specifically on AI. How to draft the patents, how to make sure that the claims of the patents are written in a way that they are broad. So she'll talk about all of these aspects. Over to you, Astha.
Thank you, Henry. So good morning, everyone. I welcome you all to this mini workshop, and I hope you all are keeping safe and healthy. And now, without much further ado, I'll walk you through our agenda for the session. So just give me a moment. So me and Henry would be your presenters for this session, and we would discuss a lot of practical aspects related to your AI innovations and what are some of the practical tips that you can use. So we start with an introduction of AI as a field and what are the components and challenges. Then we also discuss briefly about eligibility, like does your work warrant patent protection? Then we move on to the specific challenges and practical tips that we can use to overcome these. Then we briefly outline the filing and subsequent processes for patent drafting and filing processes. And we also discuss some of the government incentives and schemes in that section. And finally, we leave the stage open if time permits for some questions. So you all are aware that AI, artificial intelligence, is an emerging field, and Neha has also briefly touched upon what are the trends in this field. So when machines try to simulate human intelligence, so that is what artificial intelligence is all about. There are a lot of enabling technologies in this field. Some of these include speech processing and which includes natural language processing. We have image analysis and computer vision. Then some of the key enablers include a learning methodology and learning model and training data sets which are used to provide intelligence. Now, AI inventions can broadly be defined to have three major parts. The first part is a training aspect, second is a model, and third is an application. Now, by their very nature, because of having these three different parts, AI inventions become a little tricky to patent, and why we would see in subsequent slides. But just to have an idea of how somebody who is a practitioner or who is drafting patents sees AI inventions, so training is based on a large set of training data, and the training is mostly done in offline setup. And then the next stage comes modeling, which is the actually learning implementation. In model generation and learning, there are prediction methodologies. There is your actual algorithm, which is a sequence of computer programs, instructions, complex mathematical and statistical functions. Then there is analysis of inputs, and based on those, a model is trained on the data and it develops learning strategies, which could be of supervised learning, unsupervised learning, reinforcement learning, or semi-supervised. And based on all of these, the model generates an outcome. So the outcome of the model is related to the real world application, something that we are able to see as a tangible output. And this outcome could be in any form. It could be in the form of a control operation. For example, you want to control a robotic arm. It could be in the form of advanced analysis. It could be used in some business processes for further data analytics, trends prediction. then this outcome could also be in the form of some verifications or user notifications. For example, if we talk about some navigation applications, then based on learning based models, some notifications for driving control could be generated. So these applications tie the training and model aspects to the real world scenarios which the model is actually designed for. Then why are these inventions tricky to patent? That we will see along with who all can get a patent on their work. So if you are a startup who is developing a new technical product that relates to AI, or you can be an individual inventor researching and devising new methodologies. You could be devising a novel process for training, or you could be a large or big firm or corporate who has a continuous process of ideation and development of AI-based products and processes. And you could have a competitive strategy wherein you want to get ahead of your competition by focusing on AI domain. And as a result, you are developing products, processes, and want to get into the field of AI. Or you could be thinking of a litigation strategy, or you could be defending an ongoing lawsuit. So, if any of these scenarios fit the bill, they seem suitable, so you should go ahead and get a patent. Now, Indian patent law actually describes an application for a patent can be filed by anybody who is a true and first inventor, or is the true and first inventor's assignee, or is a legal representative of the deceased true and first inventor or his or her assignee. So that means individuals, startups, small, medium, large entities, Fortune 500 firms, R&D centers, anybody can file a patent. And when do you go for patenting strategy? So like whenever you have developed something based on your R&D, some litigation has come up, you are defending your competition, or is it part of your strategical move? So this is the right stage when you should go ahead and get a patent on your AI innovation. But before you do that, it is important to understand that what are the technical challenges and filing based challenges that we face specifically with regards to AI innovations. Now, so any novel methodology that you have devised uh, may be counted as an innovation, but every innovation might not be counted eligible for a patent. There are three key aspects that any innovation or AI innovation must have for it to qualify for going ahead for the down the roadmap of being converted into a patent. These three key aspects include novelty, which means that your product, process, methodology, it should be new as compared to what is already existing, as compared to the existing solutions to the problems that you are trying to solve. Then it should be non-obvious. Now, non-obvious is as such a very subjective term, but broadly it means that anybody who works in the same domain as you and who has technical skill which is equivalent to somebody like an inventor or somebody who's developing this AI innovation, they would not have been able to contemplate your invention without going through some serious technical challenges. So what it means is that it should not be that the invention that you have made sounds frivolous. So there should be some technical challenges and issues which you can show that you have overcome. Why your your innovation should be taken down the road of getting a patent.
Right.
And the
So
third,
Astha, I would quickly like to give an example here, just to make it clear for everyone. So for example, if someone conceived of a nut, a hexagonal nut, and some other person comes and he says, I have an octagonal nut, you could have easily conceived that, if you increase the size, the amount of pressure that would fall on the whole thing would reduce. So, and that was the purpose of a hexagonal nut. So, that would be considered as an obvious improvement, just for quickly citing an example here. Yeah, please go ahead.
thanks, Henry. And so that and the next aspect is utility or usefulness of your innovation. So in any jurisdiction, be it India or abroad, it is very important that your invention should have a practical utility or a practical use case which benefits from this innovation. So while I was also looking at some of the questions in the chat when the panelists were discussing, so one of the questions was that if your innovation does not have any market benefits, so can you still get it patented? So market benefits is one aspect, but utility is something which translates your innovation to some real world scenario. So even if it does not have some market benefits, but it has a utility, you can go ahead. And once you have identified that your innovation has at least these three aspects, you can walk down the road of getting it converted to a patent. But it is not very easy. Having the right balance of all these is very important to get a patent which satisfies, again, three criteria. It should be of high quality, because the underlying reason of filing a patent is that you should have some privileges which are exclusive to you, and you should be able to reap the rewards of your innovation. So the patent should have that much quality that it can let you provide those benefits. It should be broad enough so that you can actually go ahead and determine if there are some competitors who are trying to copy your solutions or innovation, so you can go and go after them and enforce your rights. And at the same time, the patent should be infringible. So infringible is actually the test by which you can say that some competitor's product or some process, it is overlapping with the technology that I have disclosed in my invention. So how easy it is to detect that measures the infringible aspect of a patent. So it is important to have a right balance of all these three if any one wants to really benefit from the patent and really reap the rewards of their innovation. Now, moving on, this entire path from innovation to getting a patent, it has three major stages. First of them is ideation and understanding. This phase is very important because this is where you start with your raw idea. And so when you have some idea, you conceptualize it, you document it. Then if you are in an organization setup, or if you have access to some IP experts or some other experts, so you can brainstorm and distill it down to identify those aspects of your idea which would be really profitable for you, which would benefit and which would have a more likelihood of getting a grant. Now, this is again a process which can take place through a number of stages. But once that is done, and you have identified some high quality, invention disclosure, and that is generally done in the form of an IDF, then a prior art search, which is looking at what already exists in your innovation space, that is performed. And based on that and a comparative analysis, you further refine your scope and novelty. And these steps are generally performed iteratively until you get a very high value document representing your idea. Once that is done, and you have also done a comparative analysis of your innovation vis-a-vis what exists in the art, then you can move on to the next stage, which is of drafting. Now, again, if you take assistance of some experts, so they would ideally want to discuss and define the scope of your idea before going ahead. And then a patent application is drafted. And at that stage, the discussions that are held with you as inventor or firm, so they are very valuable because it is there that the legal scope or the boundaries of your protection are identified. And once an application is drafted, then finally you can the inventor can review it and get it finalized. And so that the next stage of official processes, which is filing and grant, begins. So once a patent application is prepared, then in the jurisdiction that you want to go ahead for protection, there are patent offices. You submit filing documents and requisite fees, the prescribed fees for the type of filing that you do. Then after that is done, your patent gets into the hands of the patent office and the examiners. Based on your request, they perform an early publication or a normal 18-month publication. And then further, if you request for examination, so that is examined. There, the patent office gives their view whether they approve or disapprove of the utility, novelty, and the the innovation, and whether they decide to give it a grant or whether they refuse it. And generally, prosecution is the stage where a lot of patents get drawn. And we will look at the life cycle also of a patent in detail. But if you successfully navigate through that, then you get your innovation patented, and thereafter you pay renewal fee at stipulated time periods or every year. And then you can also think of getting monetary benefits out of it. There are numerous monetization strategies which can be then used for a granted patent. Now, I briefly touched upon the ideation and understanding phase. So this is very important because, as the saying goes, that well begun is half done. So if you are able to identify correct scope of your invention during this stage by iterative stages of documenting, brainstorming, and comparative analysis with the prior art, and then finally identifying the correct scope. So half of your battle is won because you know which areas you have to focus on in the rest of the stages. So once you are past that stage, you pass on the control to somebody for drafting your patent application. Now you could get in touch with some experts, or you could, if you have your firm provides this support, you could get it done through your in-house team. But because it is also legal matter as well as technical, so it is important that this stage is also done right. So as the patent office defines that a patent is a statutory right, and by statutory means that it is done by law, and it is a legal right, and it is granted for a limited period of time to the patentee. Generally, that limited period of time refers to the term of the patent, which is 20 years from the date of priority of that patent application, or from the earliest filing of a patent application. And during that limited period of time, the patentee has the exclusive rights of making, using, selling, and importing their patented product or a process for producing that product. Now, in order to get into this exclusive right, the first step is that you draft your patent application. And the patent application, as we also saw in some of the discussions during the fireside chat, that it's a techno-legal document. So it should be prepared with the help of some experts in the field, and in collaboration with multiple stakeholders like inventors, the R&D department if you have a big firm, or an in-house IP team, and an IP expert. So it's a joint collaborative effort which converts your innovation to a patent application. Now, there are different parts of a patent application. Uh, Title just outlines the title of your invention. Then you have an abstract, which is a 150, a nearly 150 words summary or an overview of your invention. And the detailed description of your invention comes in specifications, and specifications further have subfields, which include field or the technical field of your innovation. So, in international systems and in for search purposes, there are a number of classes, technical classes, which the examiners, the patent office, they use for identifying related art. So the technological field defines that aspect, that technical field where your invention lies. Then the next section is background or prior, which we also briefly discussed when we were discussing about ideation. So here you, as inventor, in your words, describe what is the problem that you are trying to solve, and what are the existing problems, solutions that are there, and why they are not able to overcome the challenges, or why they face some challenges, and they still have scope for having a better solution implemented, which you would be later explaining in your description. But in background, only the challenge is outlined, and the previous solutions. Then you have one or more figures which pictorially represent the concepts of your invention. And then detailed description is the section where all the remaining pieces they fit together. You describe your figures, you give detailed explanation of your concept, and you add information about the real world scenarios, you disclose the best mode of performing your invention. So all that goes into detailed description. Now, these are more or less technical parts of your application. Now, the next part, which is very important, is claims. Now, claims are the legal aspect of your application. And probably there can be independent claims or dependent claims. So, independent claims can have, they cover the novel aspects, they include the novelty by themselves. So, at India Patent Office, you can file 10 claims for which no additional fee is charged, and there is no limit on the independent claims. But beyond that, some fee is charged per claim, which we will also look at later when we discuss the fee schedule. But by far, claims are the most important aspect for your patent application. Now, why are they most important? Because claims define the legal boundary within which you will be provided protection. They define the scope of your innovation, and they also give you the exclusivity over others in the field. So even if something is there, let's say in the detailed description section or in background or anywhere in the specification, abstract or title, but that is not covered by the scope of your claims, so you cannot be given legal protection or exclusivity on that content. That is why it is most important to have your claims drafted carefully, and it is at this stage that all your discussions, your ideation discussions, brainstorming sessions, they help, the prior art analysis helps. So keeping all that in mind, the claims need to be drafted. Now, the scope of the claim has to be identified very carefully, because if it is too narrow, that is also a problem. If it is too broad, that is also a challenge. So it has to lie somewhere in between. Now, why? Because if you have a very broad claim, then that may actually lie in public domain and may overlap with some of the prior solutions that you have seen, some of the prior, and thus it may not be considered novel. And if it is too narrow, then maybe let's say you are just focusing on what you are doing in your product and you are focusing it on too much details, then it may be too difficult for you to prove infringement from your potential threats in future, or it may be too easy for them to work around your narrowly limited claim and still devise the same solution, still do the same thing that you are doing. But because you drafted your claims in such narrow interpretation, they are able to work around it. So it becomes very important to have the claims drafted with the correct scope. Now, in respect of the AI innovations, we have some very peculiar challenges, specifically when it comes to claim drafting. So we discussed that any AI innovation is a combination of a training, a model, and application. But if we use the correct combination, which is that it covers the training aspect, application, and model aspect, then we may be able to prove that we have a novel, eligible, and infringible claim or an application. But if we choose any of the wrong combinations, like let's say that we just choose to protect our model, so it may be novel, but because models are generally complex mathematical expressions, calculations, and statistics, so the patent office may reject them as ineligible subject matter. Similarly, if you try to go and protect only the training part, which maybe you think that you have devised a novel training methodology. So it might be novel, and because of the interaction of this training system with real world elements, it might even be patent eligible. But because it happens offline, it might be difficult to detect. For example, if a company uses your training methodology and implements it in their model and then develops a product, so ideally they are just doing the model application. They would not be infringing on your innovation because the training was actually done offline separately and they did not disclose it. Similarly, when it comes to only application, so that is also generally not considered novel. This application could be something like controlling a robotic arm. So this generally only applications are too broad to patent. And now let's say some combinations. Let's say you try to protect training plus model, and if a company A is doing training, but the model is implemented by some company B, So this gives rise to infringement issues like divided infringement. Now, what this means is that let's say you have protected training methodology as well as the model in your claim. So, in order to implement all the steps of your claim, both company A and company B, they have to perform jointly. Only then they would be able to implement all the steps. So, when you go for litigation, you would have to file a lawsuit against both of these companies. This generally is a major challenge later. So generally, this such combinations also should be avoided. And similarly, if you have just model and utility, so again, it could be narrow because you're saying that you are using your model for a specific application. So that may be too narrow or difficult to easy to work around for your competitors. And another interesting combination is training and utility. So if you try to protect your training phase and your utility, so it would be ideally very broad because maybe the actual model is nowhere in the picture. So because of all these aspects, it becomes very challenging to draft AI patterns with correct scope. And these are the technical challenges that we face. There are some filing-based challenges also. So we know that in earlier, at least till 2017, all of the applications that were filed for AI, so they were considered as software patents, and there were no defined guidelines. They were not well defined, because of which a lot of them were rejected because of having patent ineligible subject matter. Then in 2017, computer-related inventions were specifically assigned guidelines, and AI innovations now fall into the category of CRIs. And CRIs also define, right now they are not very well defined. They give you some of the strategies which you can use, like some of the allowable matter that they have started allowing in your inventions and specifically software patents, but still they are not that well defined. Specifically, if we compare them with global jurisdictions, like if I talk about USPTO, the US Patent and Trademark Office, so they regularly publish some examples which give examples of granted patents or frameworks. Like for AI, also they release examples of claims which can be used. But right now, we are still to catch up to that level. And as a result, under Section 3K of Indian Patent Law, most of the AI innovations get rejected as being directed to a mathematical or business method or a computer program or algorithm, which is generally what we envisage AI applications or AI innovations to be. And just because of this, there is also a little bit paucity of good reference literature and landmark cases. But still, Indian patent system is still evolving and it is adapting. And maybe in future we would have more robust framework. But right now we are still in an evolving stage. Then what should we do? Now we see that we have technical challenges, we have filing-based challenges. Then what should a practitioner or an inventor do? So first thing is that you should focus on your core competencies because you need to have a very guided focus area, a very you need to have a very specific direction that you need to follow. You need to identify where your competence and where your novelty lies. Are you a company, an inventor, or any firm who is focused on developing training methodologies, or are you developing models, or are you using them? So you have to very strategically, delve into this field and identify your competencies at the beginning of your ideation and patenting process itself, so that your priorities remain clear. And then you can further take the help of experts. So these experts could be, as what was also discussed in fireside chat, they could be some facilitators, they could be IP firms, they could be attorneys, but it is important to have their opinion so that you are actually able to leverage the benefits of your innovation, and your innovation does not get rejected just because you did not take the right guidance at the right time. And from the practitioner's perspective, it is very important to define these two features: technical effect of your invention and technical advantages. Now, technical effect by by interpretation means that an outcome or effect that your innovation produces in the real world. So it could be in the terms of, if you are using your ML model to power an actuator, or you are using some inputs from a medical database, and then you're feeding it into a model, and then you are again using it to do analysis of patient data and provide them tele advice or tele consultancy. So actually, you are tied at every stage with some real world objects or entities. So there is clearly a technical effect that your invention is producing. And second important aspect is technical advantage. So technical advantage again could be in the form of how computationally efficient the methodology that you have devised is. Is it also able to provide some economic way of implementing any processing operations? Is it able to save on some memory? Is it able to perform faster? So all these types of technical advantages, and as many as you can think of, it is imperative to clearly define them and put them down in your application, because this in the end becomes the subject matter on which a practitioner will rely to take your idea forward for grant. So in order to do that, your specification and the description, it should have sufficient support of everything that your innovation is related to. So even if you are focused on a model, you should include details of training methodology and the best mode and practical application of your invention. And once that is done, in from the claims perspective also, you need to tie your invention to some suitable hardware elements. And so by in plain language, generally when people draft claims which mention computer program product, so now patent office has become vigilant, and only citing this does not help. We have to tie some suitable hardware elements or some tangible elements from the real world that your model based innovation is effective and it is implemented through those. Such hardware elements have to be identified throughout your specification, and specifically in the claims, they need to be mentioned so that your invention does not fall into the category of patent ineligible subject matter. If all of these practical tips are taken care of, then it increases the likelihood of getting a grant on your patent much more. Now,
I think, Asta, we are short of time. I think we can move to the filing part quickly, and
yes. So this is the next stage that we had. That how what are the processes that you do for filing? So you can either file a provisional or complete specification, and based on that, your if you don't file a complete application after provisional, your application might get abandoned. But if you do that, the next stage is that your application goes for an examination with the patent office when you file a request for examination. If it is not filed again, the application gets abandoned. But if you do, then the patent office issues their opinion in the form of a first examination report. You respond to FAR with your opinion, and either it could be accepted by the patent office and eventually you get a grant, or it might not be accepted and you might get into a hearing session with the examiner where you try to explain the strategy and novelty of your innovation. Again, based on the outcome, whether the examiner is convinced or not, you get a grant or your patent goes for a refusal. These are some of the official fee that we have tried to highlight, and they vary for e-filing and physical filing, and they also vary for the type of entity who is filing an application, whether you are an individual and a startup, a small entity, or others. And details of these can be obtained from IP India website's detailed fee schedule page, for which we have provided a link here. And yeah, this is very important. Government of India has actually launched several initiatives for startups and MSMEs, and just to promote awareness of IP and also to establish transparency. So, like a cell for IPR promotion and management has been set up to provide awareness about IP material and IPR, and with specifically curated contents for the type of institution. Then there is a mobile app and e-learning platform L2 Pro, which again has the intent of spreading awareness regarding IPR. There is a very important patent facilitation program. As part of this, at state level, 24 patent information centers have been implemented in various states, and they have further led to establishment of 84 intellectual property cells in universities. So they cater to inventors from government organizations and state universities and provide assistance to them in getting their ideas patented and filed. Another important achievement is that the Indian Patent Office and Japanese Patent Office (JPO) they have entered into a bilateral agreement called Patent Prosecution Highway, as part of which both of these jurisdictions can leverage expedited examination of their applications. And currently, there is a limit of 100 applications per year, which can be examined under this program. Then there are several technology and innovation support centers, which the World Intellectual Property Organization, in collaboration with DPIIT, the Department for Promotion of Industry and Internal Trade, has set up, and they plan to provide IP services like technical resources, databases, and even strategic information. Then several other schemes that are available for startups and MSMEs are that they are eligible for 80% fee rebate in their official fee that is related to filing and all the later stages as compared to large companies. Then for startups, there is a provision to get their examination, patent examination and publication expedited. And this is very important if you want to get ahead of competition. Then in 2016, the SIPP scheme, the Startups Intellectual Property Protection Scheme, was launched, which Henry also discussed briefly in the fireside chat, as part of which 289 patent agents, and the list is also getting updated, have been empaneled. They are facilitators for startups, and they provide assistance in preparing, filing, prosecuting their patent applications, and all the fee of the facilitators is borne by government. Then specifically for ICTE sector, there is this SIP EIT scheme where financial support is provided for international patent filing in this sector, and a maximum reimbursement of up to 15 lakh per invention, or 50% of the expenses which are incurred in filing such an international patent, whichever is less, that is provided. And currently, only one application can be filed with this scheme. And another very good initiative is building awareness on intellectual property. So some of the salient features of this building awareness scheme are that there can be a financial support of up to INR 1 lakh for organizing awareness or sensitization programs. There can be a support of up to 2.5 lakh per pilot study to identify IP needs of MSME clusters, industries, and expert agencies. Then there can be a financial support of up to INR 2 lakh for organizing interactive seminars or workshops. And there's a financial support of up to INR 6 lakh for organizing short-term training programs, and 45 lakh lump sum for organizing long-term training programs. There is a financial support of 1 lakh on grant of a domestic patent and 5 lakhs on grant of a foreign patent. Again, there is a support of 1 lakh for registering a GI or geographical indication, which is another form of intellectual property, and 65 lakh for setting up of IP facilitation center. More details are available on this link, which is provided, and which we can also share this later in an open forum. But all of these initiatives are aimed at assisting all the startups and inventors and promoting this culture of awareness. These are some of the important resources that we have provided. You can have information of these resources available after this session. There are guidelines, there is search tool of patent office, there are form and fee details, there is a manual of procedures how the patent office operates. Then there's a utility for e-filing of your patents. Then the startups protection scheme, that details can be accessed here. And then list of facilitators can also be accessed. Then there's a startup recognition form which you need to fill for availing some of these benefits. So I think with that, I have come to the end of my session, and we have tried to answer some of the questions that we initiated, like can we get a patent for software product, so you can still file a patent within a grace period of 1 year. And if you are developing a novel training methodology, but still you tie it to your hardware, you can still get a patent. So all this we have tried to address, and I think now I'll put the stage open for having more questions from the audience. If they want to put forward some questions, they can do so in a chat.
Yeah. This was very helpful, Asta. Thanks a lot. And I think I would like to pass it back to Neha to thank everyone, for this session. And, in fact, the last, these couple slides, these were really interesting and, very helpful, I'm sure, for the audience. And they can go offline and take a look at all of these links and how they can avail these, incentives. Back to you, Neha.
Thanks, Vaibhav, and thanks, Asta, for such insightful details that people now can really refer back to in terms of filing their AI patents. And for the benefit of the audience, we'll share the complete recording soon, and keep following India AI and NASSCOM Research Twitter handle, so you'll get to know, when the recording is up. And before we close the session, I would just like to thank everybody who attended the session, our speakers, Anand, Gagandeep, Vaibhav, Astha, for taking their time out. And it was really an insightful session, and we look forward to more such sessions going forward. And I hope everybody stays safe, and do read the report. We'll be looking forward to your suggestions. We'll also try to answer most of the questions, and we'll follow up that with a tweet chat. So stay tuned on the Twitter handles, and we'll let you know what next. Thank you.